We're calling the case. My name's Jackson Lucky. We're calling the case of Marks versus Sonny's.
I'm sorry, can I interrupt for a second? So I'm looking at my score sheet and I'm having great difficulty in finding those names on my score sheet. Am I got the wrong round here or something?
I believe there should be sort of a drop-down box somewhere.
I know I did it this morning. I know what I'm supposed to find, but
okay.
I'm just not seeing these two names on my drop-down box.
I have them on mine.
I'm sure you do.
Why don't I?
So should I just score for Patel versus O'Hara, because that's what I get for roommate.
What I can do is post into the chat the link to the current ballot, Mr. O'Brien. And so if you open your chat window, try clicking on that link and see if that gets you there.
All right. So that's going to, okay. So I was trying to do it on my phone, but I guess I'll do it on my computer. I'm still showing one. Okay, so what are the two last names again?
Mukavitz versus Joseph, and they're alphabetical by plaintiff's counsel.
Okay, I've got it, and I'm in business, and I shall now mute myself.
Outstanding.
Perfect. All right.
All right, then let's call the case of, now I'm trying to remember our party's names, Marks versus Sonny's Rooftop Bar, which I should know since this is the third time I've heard this trial. And let's get appearances, starting with plaintiff's counsel.
Yes, Your Honor. My name is Lauren Mukavitz, and I, along with my second chair, Ms. Kira Lentz, will be representing the plaintiff in today's trial, Ethel Marks. Ms. Lentz, she will be helping me with the technology and the exhibits in today's trial, and her audio and video will remain off for the duration of today's trial.
Thanks, Ms. Mukavitz. And for defendant.
Good evening, Your Honor. My name is Joshua Joseph. I'm joined today by my second chair, Ms. Isabella Dietrich.
Good evening, Your Honor.
Together, we represent the defendant, Sonny's Rooftop Bar, represented in court today by Mr. Sonny Mehta, the owner.
And good evening, Mr. Mehta. All right, any preliminary matters before we get on with opening statements?
Yes, Your Honor. May the plaintiff invoke rules 603 and 615 to constructively swear in all witnesses and sequester them from the jury?
Yes, we'll consider all witnesses constructively sworn in and sequestered.
May we assume that all exhibits that are shown on screen that have yet to be admitted are shown constructively outside the presence of the jury?
Yes, without having to go through the ceremony, we'll just consider everything that is first displayed to be outside the presence of the jury. And then once authenticated and moved into evidence, we will publish to the jury without need of counsel asking.
And finally, Your Honor, we'd like to ask a brief clarification question. Point 8 of the pretrial order states that once exhibits are admitted, counsel performing an opening, examination, or closing may display such exhibits on screen at any time without specifically requesting permission. We'd like to know your preference as to exhibits that are not yet admitted. Would you like us to request permission to screen share or simply have the record reflect that we are screen sharing?
We'll just have the record reflect, as I said, the first time we show something, obviously an opening, if you have a good faith belief it's going to come into evidence, you may display it without requesting anything from the court. Once we start testimony, they'll be constructively outside the presence of the jury. And I'm presuming that you're not going to use anything other than a demonstrative in closing argument that you haven't had admitted into evidence.
Yes, Your Honor. And with that, the plaintiff is ready to proceed.
And does the defense have any preliminary matters, Mr. Joseph?
Yes, Your Honor, a couple. First, Your Honor, we just like to highlight that our party representative is Sunny Mehta, and although witnesses are sequestered, because he's our party representative, he should remain during the trial.
Yes, granted.
Sorry, Your Honor, she should remain during the trial. Additionally, Your Honor, we have a few documents that we think might be helpful for you during trial. Specifically, the pursuant to pretrial order. Sorry, Your Honor, specifically the complaint, pretrial orders and stipulations. And we're putting a copy of those documents in the chat in case you don't have them already.
Thank you.
Additionally, Your Honor, we'd like to draw your attention to pretrial order 2. Pursuant to pretrial order 2, Judge Pasquarello has granted a motion to bifurcate the case. Today's trial will deal only with liability and not with damages.
All right.
And lastly, Your Honor, in our answer to the plaintiff's complaint, we raised 2 affirmative defenses. We'd just like to make it clear that we won't be pursuing either of those defenses at trial today, but instead we'll be disputing the plaintiff's last of the 4 elements, causation. Specifically, we'll be arguing that Sunny's rooftop bar didn't cause Jessica Marks's death, and instead making the argument that her own choices did.
And counsel's free to abandon any affirmative defense, and you don't have to warn me if you're just going to contest an element of the cause of action from plaintiff.
Yes, Your Honor. And with that, the defense is ready to proceed to trial.
All right, then I'm going to ask our viewers to turn on to the speaker view, and we'll commence with opening statements.
May I proceed?
Yes.
Your Honor, opposing counsel, members of the jury. We've all heard the joke about a man walking into a bar. But what happens when a minor walks into a bar? A minor who's already showing signs of intoxication as they walk through the door. And what happens when that minor is served drink after drink after drink, till they're stumbling and they smell of alcohol? And the bar? What happens when that bar doesn't stop them? What happens when that bar ignores the signs and simply watches as that minor walks out the door into their car? Well, they get into an accident. But members of the jury, this isn't simply a hypothetical. It's not just a story, and it is most definitely not a joke. This is real. Because on March 24th, 2019, Jessica Marks walked into Sunny's rooftop bar. They ignored the signs. And now Jessica Marks, she's dead. We are here today because she died. We're here because in the state of California, any business licensed to sell alcohol, they're liable for any injury or death that results from them serving any obviously intoxicated minors. And today, we as the plaintiff have the burden of proof. We have the burden of proving to you by a preponderance of the evidence that it is more likely true than not that Sunny's rooftop bar served Jessica Marks when she was 19 years old and clearly intoxicated. And that was a substantial factor in her death. Now I know that was a lot. So let's take a step back to March of 2019. Jessica Marks, she's 19 years old. She's a freshman in college and she's here in LA visiting her childhood best friend, Morgan Levin, for spring break. The 2 friends, they go to Sunny's on March 24th, 2019. They get there around 9 p.m. and they get a table up on the roof. The bar's owner, Sunny Mehta, was actually the one to serve them. But today, Morgan Levin will tell you that as the night went on, Jessica got louder. She stopped making sense. Her eyes got red and watery, and at one point she stumbled. She stumbled on the very stairs that Sunny Mehta will tell you she and the other bartenders used to determine whether someone is too drunk to drive. And when she stumbled, members of the jury, she bumped right in to Sunny Mehta. But Miss Mehta, she didn't cut Jessica Marks off. She didn't take her keys, give her water, or call her an Uber, and neither did the other bartender, Frankfurt Johnson. They ignored the signs, and they simply watched as Jessica Marks walked out that door into her car. Which is why, members of the jury, At the end of today's trial, I will come back before you and ask that you find Sonny's Rooftop Bar liable for the death of Jessica Marks. Thank you.
Thank you, Ms. Mukavitz. And Mr. Joseph, are you reserving or are you making your opening statement at this time?
I'll be making my opening statement, Your Honor.
Whenever you're ready, sir.
May it please the court, Ms. Mukavitz, members of the jury, choices. The case you're about to hear today is a case about choices. Now, Ms. Mukavitz just got up here and told you the story of Jessica Marks. It's a tragic story. Now, as the defense, we sympathize with the pain and loss that the Marks family is going through. We know how difficult it can be to lose a child. Well, it's only natural to look for somebody who's responsible. Members of the jury, this is a court of law. And today you have a question that you need to answer. Whose choices led to this tragedy? Because you'll learn that this case is a case about choices. Choices that Jessica Marks made. And unfortunately, you're going to hear that Jessica Marks made a series of tragic choices. The choice to go to a bar underage, the choice to drink alcohol, and then the choice to drive home afterwards. Choices. Now I want you to meet the owner of Sonny's Rooftop Bar. Miss Mehta, could you please turn on your camera for just a moment? Members of the jury, this is Sonny Mehta. She's a hardworking small business owner who loves to get to know her customers and meet new people. Now the plaintiff has come to court today to sue Sonny's Rooftop Bar for wrongful death. They're using a law called the Dram Shop Act, a California law that holds bars responsible for any injuries caused by overserving. As the plaintiff, they hold the burden of proof. They have to prove the elements of this case by a preponderance of the evidence. But simply, they have to prove 4 things more likely than not. The first thing, that Jessica Marks was a minor. The second, that Sonny's Rooftop Bar served her alcohol. The third, that Jessica Marks was obviously intoxicated when she was served that alcohol. And the fourth, that serving Jessica Marks alcohol is what caused her death. And as a defense, we actually agree with Ms. Mukavitz on a couple of things. We agree that Jessica Marks was a minor. We agree that Sonny's Rooftop Bar actually served her alcohol. We even agree that Jessica Marks was obviously intoxicated when she was served that alcohol. Where Ms. Mukavitz and I disagree is on who's responsible. We disagree because Jessica Marks made her choice. Today in court, we're going to hear how Jessica's own tragic choices are what led to her death. The choice to go to a bar, the choice to drink alcohol, and then the choice to try and drive home. Choices. But to tell us about some of the choices that Jessica Marks made, you're going to hear from her best friend, Miss Morgan Levin. And even though it's Ms. Mukavitz who's going to call Morgan Levin to the stand today, on cross-examination, she's going to tell you about those series of choices that Jessica made. She's going to explain that Jessica Marks was planning on driving to and from Sonny's bar that night. She'll even tell you that despite making that plan, they both started drinking alcohol before even leaving for the bar. I arrived at Sonny's and made the choice to order several more drinks. And Morgan Levin's going to tell you that when the night was over, instead of getting in her Uber that was sitting right there, Jessica Marks made the choice to drive home. Choices. Today in court, you're also going to hear from the owner of the bar, Miss Sunny Mehta. Now, Miss Mehta admits that she served Jessica Marks alcohol, but you'll hear that at the end of the day, she simply can't control the choices that her customers are going to make. And you'll hear that if she had known Jessica's plan to make this choice to drive home, she would have stopped her. Like she's done before, she would have taken her keys and called her a cab. She didn't know that Jessica was going to make that choice. Members of the jury, you're here to determine who is responsible for Jessica Marks' death. You're here to ask yourself whose choices caused it. Sadly, today in court, you're going to see that it was Jessica Marks' own choices that led to her death. At the end of this trial, I'm going to ask you to make your own choice. I'm going to ask you to hold the defendant liable, not liable. Thank you.
Thank you, Mr. Joseph. Plaintiff's first witness. And we'll consider the witness sworn, and I'll remind our spectators and scorers to switch to gallery view for easier viewing. And Ms. Mukavitz, whenever you're ready.
Good afternoon. Please introduce yourself to the court.
Hi, I'm Morgan Levin. I'm a junior at UCLA, or I'm going to be one in the fall. I'm studying biology. I'm 21. Is there anything else you need?
No, that's fine. Did you know anyone by the name of Jessica Marks?
Yes, ma'am, I did.
How did you two know each other?
Well, she was my best friend. She was my lifeline. Well, really, she was my everything.
Did you two go to school together?
Yeah, that's where we met, actually. We met in junior high. It must have been sometime in 7th grade, 2013.
What about college? Were you at the same college?
Well, no, when we graduated, I went to UCLA over here, and she went to Drexel.
Now, Mr. Levin, I want to talk to you about March in the year of 2019. Do you remember that time?
Vividly.
At any point during that month, were you with Jessica Marks?
Yes, ma'am. She came to visit me in LA. We hadn't seen each other in a while, so it was really nice to see her again.
Did you two do anything fun when she was visiting?
Yeah, there's one time we went to Disneyland. We had a lot of fun there.
Mr. Levin, I want to bring you forward to March 24th, 2019. Do you remember that day?
Seared into my brain.
Were you with Jessica Marks that day?
That night, too.
Did you go to Sunny's rooftop bar?
Yes, ma'am.
Now, Mr. Levin, I have to ask, how old were you in March of 2019?
Me, I was 19.
How old was Miss Marks?
She was 19 too. You know, we shared a birthday, actually. I had joint parties, blew out cakes together, that kind of thing.
Your Honor, let the record reflect that I'm showing Mr. Levin what has been previously marked as Exhibits 3 and 4.
Yes.
Mr. Levin, can you tell us what Exhibits 3 and 4 are?
The one on the left is a picture of Jessica, and the one on the right is a picture of me. Those are our fake IDs.
Are they fair and accurate copies of your fake IDs?
Yeah, I mean, they're fake, but they're accurate as far as they're shown.
Your Honor, the plaintiff moves Exhibits 3 and 4 into evidence.
Any objection?
Yes, Your Honor. I'd object to relevance under Rule 401. May I be heard?
Yes.
Your Honor, it's been previously stipulated, and all parties agree that Jessica Marks was a minor at the time of her death. It's stipulated that she was 19. Her using a fake ID at Sunny's rooftop bar is irrelevant. Not a single one of the elements of opposing counsel's burden have to do with failing to do their due diligence at checking IDs, or that Morgan and Jessica tried to deceive Sunny into thinking that they were older. The only element this is related to is establishing that Jessica was underage, but that evidence has already been on the record.
Ms. Mukavitz.
Yes, Your Honor. The choices made by Sunny's rooftop bar are extremely relevant today in today's case. If allowed to continue, Mr. Levin will tell you that on March 24th, 2019, Miss Marks and him, Mr. Levin, went to Sunny's rooftop bar and used these fake IDs. And the choices made by Sunny's rooftop bar are just as important as the choices made by Jessica Marks and Morgan Levin, and are extremely relevant in today's case.
Your Honor, may I respond?
Not yet, sir.
Yes, Your Honor.
Ms. Mukavitz, Mr. Joseph says that these don't relate to any element of the causes of action you've alleged. I haven't heard you articulate what element this this evidence would meet as to the causes of action you've alleged.
Yes, Your Honor. This does go to the fact that my apologies. This goes to the fact that Jessica Marks and Morgan Levin were minors on March 24th, 2019. And although that is stipulated to the use of these IDs and the acceptance of them by Sunny's rooftop bar, it goes directly to the carelessness of Sunny's rooftop bar in serving two minors by choice.
Your Honor, may I respond?
No, I'm still trying to follow the argument. It might be my thick-headedness. Ms. Mukavitz, I didn't see recklessness as an element of any of the causes of action you've alleged. And maybe you can help me understand this a little better.
Yes, Your Honor. Recklessness or negligence, it's not one of the causes that we have alleged Sunny's rooftop bar has done on March 24th, 2019. However, if Sunny's rooftop bar had done their due diligence, if they had checked Jessica Marks's ID, we wouldn't be here today. And if allowed to continue, Morgan Levin will tell you that when they got to the bar, Jessica Marks was already showing signs of intoxication. But Sunny's rooftop bar, they ignored the signs and they served them anyways, even with these IDs. And that goes directly to our burden today.
The objection to relevance is sustained.
Yes, Your Honor.
Ms. Lentz, if you could take those down. Mr. Levin, did you go to a bar called Sunny's Rooftop Bar?
Me and Jessica did on March 24th. Yeah, 2019.
And what time did you get there?
It was later in the evening, maybe around 9 p.m.
Had either you or Miss Marks been to Sunny's Rooftop Bar before?
Well, Jessica didn't live in the area, so no. I also hadn't been there personally, but Sunny's had a reputation for not carding, so we decided to go to that place.
Objection, Your Honor. Character evidence pursuant to Rule 404. May I be heard?
Yes, briefly.
Yes, Your Honor. Opposing counsel is using evidence that Sunny's Rooftop Bar might not have ID'd them in the past to go and prove conduct in conformity, that because that they may have had a careless instance in the past, that they're going to be careless again and didn't do what they needed to do to make sure that Jessica Marks was not being overserved.
Your Honor, may I respond? Your Honor, Mr. Levin just testified that Sunny's Rooftop Bar had a reputation for not carding. And this is admissible under Rule 405A as character evidence of someone's reputation. This is their reputation, and we aren't eliciting any specific instances of them not carding, simply the reputation that they had around town to not card. And that was the reason that that Miss Marks and Mr. Levin went to Sunny's Rooftop Bar.
Mr. Joseph, it's your objection. I'll give you the last word.
Yes, Your Honor. Opposing counsel has yet to lay any foundation as to how that was Sunny's Rooftop Bar's reputation. If I may proffer, It actually was the reputation of the bar previous to Sonny's rooftop bar. And when Sonny bought the bar, it had that reputation. This is misleading the jury, as it wasn't actually Sonny's rooftop bar's reputation to begin with. It was the bar prior to it.
All right. The reputation must be relevant to one of the elements of the cause of action. You don't get in a bad reputation for something just because it sounds great. The objection is sustained. And the answer in terms of the bar having a reputation for not carding is stricken. The jury is instructed to disregard. Ms. Mukavitz.
Yes, Your Honor.
Now, when you got to Sonny's rooftop bar, Mr. Levin, did you order any drinks?
Yeah, Jess and I had a couple drinks.
I'm showing you what has previously been marked as Exhibits 17. Your Honor, let the record reflect that I'm showing Mr. Levin Exhibit 17.
It will.
Mr. Levin, what is Exhibit 17?
That looks like the receipt for the night.
And is that your signature at the bottom?
Yeah, that is.
Is it a fair and accurate copy of your receipt?
I think so, yes.
Your Honor, at this time, the plaintiff moves Exhibit 17 into evidence.
Any objection, Mr. Joseph?
Yes, Your Honor. I'd object to hearsay under Rule 801, as the statements in blue, namely the signature, total, and gratuity, are all out-of-court statements written by Morgan Levin being offered for the truth of the matter asserted.
What truth is plaintiff asserting with the gratuity, total, and signature? Are they trying to prove that the tip was indeed $20?
Yes, Your Honor. I believe that those statements, the truth that they assert is that the gratuity was actually $20. The total was $149.58, and that was Morgan Levin's signature.
Ms. Mukavitz?
Your Honor, we are not using the gratuity or the total of this exhibit. We are using the signature of Morgan Levin to show that this was the correct receipt. And insofar as there are any hearsay statements in the exhibit itself that Mr. Joseph has any objection to, they fall under the 807 exception for residual hearsay.
All right. In terms of the signature, I think that goes to laying foundation for authentication of the exhibit, not for the truth of the matter asserted. I don't think the gratuity or total are issues in this case. And to the extent that there are any further documents, I think that there has been at least a prima facie showing that these would be admissions on part of the entity defendant. The objection is overruled and the Exhibit 17 is admitted.
Yes, Your Honor.
Mr. Levin, can you tell us how many alcoholic drinks are on this tab?
I'm sorry, my vision isn't exactly 20/20. Give me. It looks like the decoy red, and then 4 for the White Claws, 5, 6, 8. 8 total, yeah.
And which of these drinks did you personally drink?
Had a glass of the red, a beer, and one of the green tea shots.
Did Miss Marks drink the rest?
Yes, ma'am, she had the rest.
Did you notice any shift in her demeanor?
You mean whether she was starting to be a little drunk?
Did her demeanor change at all throughout the night?
Oh, yes, ma'am. You know, when you have so many drinks at a bar, you're gonna let loose a little bit. She started to slur, started being a little loud, not making too much sense.
And at any point during the night, did Sonny's rooftop bar cut Jessica Marks off?
No, ma'am.
At any point, did they take her keys?
No, ma'am, though I wish they did.
And at any point, did they call her an Uber or a taxi?
No, ma'am.
Thank you, Your Honor. I have no further questions.
Ross?
Yes, Your Honor. Good afternoon, Mr. Levin. I want to start by talking about some of the choices that Jessica Marks made. Let's start at the beginning of the night. You and Jessica Marks made the choice to go to Sunny's rooftop bar, right?
Yes, sir.
You and Jessica made that choice even though you knew you were underage.
Yes, sir. We had our IDs and well, we went.
Jessica Marks made the choice to drive her own car there, right?
Yes, sir.
But before even driving there, she made the choice to have a glass of wine, right?
Yes, sir. At the Airbnb before we'd gone to Sunny's bar, we each had a glass.
But Jessica didn't just have one glass, right?
She must have had one or two.
And then after that, she got in her car and drove you and herself to the bar, right?
Yes, sir.
And then after that, you both got out and went inside.
Yes, sir. That's right.
You sat on the rooftop.
We both did. Yeah.
Now I want to talk about you and Jessica's choice to drink underage. You and Jessica ordered drinks while you were at Sunny's rooftop bar, right?
We did. Yeah.
And you'd agree with me that you and Jessica both made the choice to drink these drinks.
I mean, yes, sir. We held the bottle up and put it in our mouths.
Jessica ordered all of her own drinks for herself.
Yes, sir. When Sunny Meta came to our table, we both each ordered.
Nobody ever ordered for Jessica.
Not that I know of, no, sir.
That was her own choice.
I guess so, if you say so, sir.
I'm sorry, Mr. Levin. Is that a yes to my question?
That she ordered her own drinks?
That ordering all of those drinks was Jessica Marks's own choice.
Oh yeah. When she was ordering drinks, yes, sir. I guess that was her choice to order.
Now I want to talk about another choice that Jessica made. The
Okay.
choice to drive home. At the
Yes,
end of
sir.
the night, you and Jessica left Sunny's rooftop bar around 12, right?
Yeah, just before 12, just before midnight, maybe 11:45 or something like that.
You and Jessica didn't leave together.
No, I Ubered and I insisted that she also take an Uber because she wasn't looking so great, but she drove off in her own car, and I've got to live with the mistake that I made, that I didn't drag her in, because if I had, she might still be here today.
Exactly, Mr. Levin, you called yourself an Uber, didn't you?
Yes, sir.
Like you just said, you begged Jessica to get in that Uber, right?
I tried so hard. I only wish I tried harder.
But Jessica didn't want to get in your Uber, did she?
No, sir. She insisted on driving herself.
She didn't make the choice to get in your Uber?
No, sir. She resisted.
Like you said earlier, she wanted to drive herself, didn't she?
I mean, yes, sir. She had a car there, so I assumed she wanted to get it home. I told her we could have picked it up in the morning when we were both okay.
Exactly. She even denied picking up her car in the morning because she wanted to drive the night of March 24th.
Yes, sir.
And it was her choice to try and drive home, wasn't
It was.
it? Sunny Meta didn't influence that choice, did she?
I mean, no, Sunny Meta didn't force her in her car or anything, no.
Exactly. Thank you, Your Honor. I have no further questions.
Redirect?
Yes, Your Honor. Mr. Levin, at the beginning of the night, were you at an Airbnb?
Yes, ma'am. Me and Jessica were, yeah.
And to get to Sunny's rooftop bar, did you and Miss Marks drive?
Yes, ma'am. We took a rental car.
Now, we heard during cross-examination that you and Miss Marks were drinking. Did you notice any signs of alcohol from Miss Marks as you were driving?
Not really as we were driving, but once we'd gotten to Sunny's, she was showing some signs.
What signs was she showing?
Nothing too crazy at the time. You know, she'd only had 1 or 2 glasses of wine. She was slurring little bit. She was a little bit all over the place, but nothing too bad at the time.
And did anyone at Sunny's rooftop bar note this?
You know, at some point, Miss Meta said we shouldn't let this one drive.
Thank you, Your Honor. I have no further questions.
Any further cross?
Brief recross, Your Honor. Mr. Levin, just to make it clear to the jury, like you said on direct examination, you offered to leave Jessica Marks's car at the bar overnight, right?
Objection, Your Honor. This goes outside the scope of redirect.
Your Honor, may I respond?
Briefly.
Opposing counsel opened the door to talking about Jessica Marks driving to and from the bar when asking questions about Jessica Marks driving her car. I'm just merely inquiring about what her plan was to do after she drove there when opposing counsel talked about it.
Objection sustained.
Yes, Your Honor. Mr. Levin, at the beginning of the night, Jessica Marks chose to drive, didn't she?
Yes, sir. I mean, I guess so. She put her hands on the wheel and hit the gas.
She wanted to drive to and from Sunny's bar, didn't she?
I mean, she did.
Thank you, Your Honor. I have no further questions.
Any further direct?
No, Your Honor. May Mr. Levin be excused?
Yes, thank you, Mr. Levin. You can step down.
Thank you.
Any further witnesses for plaintiff?
No, Your Honor. However, may we read something from a pre-admitted exhibit into the record?
Yes, which exhibit?
Exhibit 22.
And Mr. Joseph, you agree that exhibit 22 is pre-admitted?
Yes, Your Honor. Exhibit 22, 23, and Exhibit 1.
Anytime you're ready, Ms. Mukavitz.
Thank you. Ms. Lentz, if you could get that up for us. We'd like to draw your attention to the toxicology portion of this exhibit. The toxicology portion states that blood drawn at the scene of the accident contains 0.16 grams per 100 milliliter of blood, BAC. Blood drawn at 3:25:19 at 2:00 a.m. contains 0.12 BAC. Thank you, Ms. Lentz.
Thank you.
And with that, the plaintiff rests.
Thank you, Ms. Mukavitz. Mr. Joseph, your first witness.
Yes, Your Honor. At this time, the defense calls Ms. Sunny Meta to the stand.
And she has been previously sworn. You can inquire.
Yes, Your Honor. Good evening, Ms. Meta. Could you please introduce yourself to the jury?
Yes, of course. My name is Sunny Meta. I'm a business owner here in LA.
Tell us a bit about yourself.
Well, as I mentioned, I'm what I would call a bit of an entrepreneur. My passion lies in starting businesses and growing them. I used to have a bar named after myself called Sunny's Rooftop Bar.
How long have you owned Sunny's Rooftop Bar?
Gosh, it must have been for, I'd say 3-ish years before I had to close it.
And why did you choose to open up a bar?
Well, so I never went to college, and I found that a lot of my peers, that's where they would go spend their money. That's what they enjoyed. That's what they would do in their free time. And with me, I didn't have a whole lot of time to, go and have fun with my friends like that because I was having to work any job that I could get. So once I had the opportunity to start something, I wanted to bring a business where people could connect and have a bit of fun.
Ms. Meta, I want to start by talking about some of the allegations against you. Did Jessica Marks and Morgan Levin go to your bar on the night of March 24th?
Yes, they did. I saw them arrive around 9 p.m.
Did you serve them alcohol?
I did.
Even after they were intoxicated, did you continue to serve them?
Yeah. Upon reflection, on that night, I didn't think that they were obviously intoxicated. To me, on that night, they looked buzzed, but after reflecting on it for the past couple of months, I realized that I should have known better.
Now I want to talk about how much you and Jessica Marks actually interacted that night. Did you speak to Jessica a lot?
I mean, I remember going to their table around 8 or 10 times. One of my goals with my businesses is to really connect with my customers and make them feel like they belong and like they're in a safe environment. So every time that I talk to a customer, I like to stick around for a minute or two to chat. But there were 20 other people there at the bar that night, so that was really the longest time that I was able to stay with Jessica.
Would you say you ever talked with Jessica for over 1 minute?
Yeah, probably.
Now I want to talk about some of the choices that Jessica Marks made. Ms. Dietrich is screen sharing a chart. Let's start with Jessica's choice to go to a bar underage. Around what time did she arrive at your bar?
I remember it being around 9 that night.
And where did she sit?
She sat up on a rooftop. She sat more towards the side that overlooks the ocean with her friend Morgan Levin.
Just to make it clear, do you know whose choice it was to go to your bar?
I mean, from what I could see, Miss Marks was having a lot of fun. She was the one pulling Mr. Levin into the bar. So just from what I observed that night, it seemed like Jessica was the one who wanted to be there.
Now I want to talk about another one of Jessica's choices. The choice to drink alcohol. Ms. Mehta, did you ever serve Jessica Marks and Morgan Levin the night of March 24th?
I did. There was only one other employee there who's mixing the drinks, so I was the one serving the tables.
When you were serving the tables, who ordered?
I remember both Mr. Levin and Miss Marks ordering around the same number of drinks, but each of them were ordering for themselves.
And whose choice was it to place those orders?
Yeah, I would assume that both of them made their own decisions to order the drinks.
Did you ever force anybody to drink at your restaurant?
No, of course not. Like I said, I want my bar to be just a place where people can have fun, somewhere people can come to lay back and just relax. I would never do that.
Did Jessica and Morgan have to order alcohol?
By no means, that's not a rule when coming into my bar.
I want to talk about another choice that Jessica made. The choice to try and drive home. Did you ever talk to Jessica and Morgan about driving?
Yeah. This one time I brought them another round and was chatting a little bit with them. And I kind of noticed that Jessica and Morgan a little bit too, but more so Jessica seemed what we call in the bar industry buzzed. So I made a comment and I was just like, well, I hope this one isn't driving. And that turned out to be a horrible mistake of mine.
But just to make it clear to the jury, did you see Jessica get into her car?
I did.
Did you see Jessica drive off?
Yeah. The bar was closing at 12 that night, so we were wrapping up. And yeah, I saw her leave and drive off.
But if you had known the whole time, before she actually got in her car, that Jessica Marks was going to make that choice, what would you have done?
I would have cut her off. The moment I saw anything, the moment I saw that she started to seem buzzed, I would have cut her off right then. Her and her friend.
Have you ever had to cut somebody off before?
Yeah, I have to do it about once a week. There's always someone in our bar who goes a little too hard.
Have you ever had to take somebody's keys?
I wouldn't say take someone's keys, but I've called people an Uber before.
Have you ever called anybody a cab also?
Yeah, Uber, a cab, it's pretty commonplace.
And just to be clear to the jury, whose choice was it to try and drive home?
You're asking my opinion. It seemed to be Jessica's.
Thank you, Your Honor. I have no further questions for this one.
Cross?
Yes, Your Honor. Ms. Mehta, in order to open your bar, you had to take a class on beverage responsibility, correct?
The training covered learning about not serving a minor, learning about symptoms of obvious intoxication, everything that keeps me responsible for my customers.
And Ms. Mehta, some of the symptoms that you were taught to look for were talking loud,
Yes,
slurred speech,
that's correct.
loss of coordination,
That is a telltale sign, I will say.
and red or watery eyes.
That's right.
Your Honor, let the record reflect I'm showing Ms. Mehta what has been previously marked as Exhibit 10.
Yes.
Ms. Mehta, this is a copy of a video that you were shown, correct?
Yes, I was shown it when that attorney took my deposition.
And from what you can tell on your screen, this is a fair and accurate copy of that video?
Yeah, I haven't seen the video as of right now, but from what I can see, it seems to be the video that was shown to me.
Your Honor, at this time, the plaintiff moves Exhibit 10 into evidence.
Any objection?
Yes, Your Honor. I'd object to a lack of foundation as, may I be heard?
Yes.
Your Honor, if I may proffer, this witness will testify that they were nowhere near this video when it was being filmed, that they didn't even know that this video was being filmed, and this witness isn't able to establish onto the record when this video was filmed or even who filmed it. This video was actually taken by Morgan Levin, and if opposing counsel wanted to enter this exhibit, they should have entered it on Morgan Levin, who can actually testify to its contents. This witness has no idea.
Ms.
Your Honor,
Mukavitz?
Your Honor, Ms. Mehta, she just testified that she was already shown this video. She has already seen the contents. And if I may proffer, the contents of this video show the demeanor of Jessica Marks on March 24th, 2019. They show how she was acting at Sunny's rooftop bar. And Ms. Mehta, well, the use of this video will show that she made the choice to ignore the signs. She just testified that there are certain signs for intoxication. And this video will show Jessica Marks showing those signs exactly.
Ms. Mukavitz, I understand your argument, but I think that Mr. Joseph's objection was different. It was that this witness has no personal knowledge as to whether this video fairly and accurately depicts the decedent's demeanor at or near the time of this incident. I will take it as a given that she's been shown this video before, but I agree that at least at this point, there hasn't been a foundation that this video is a fair and accurate representation of the decedent's demeanor at the time that this witness saw the decedent.
Your Honor, would you like me to lay some more foundation?
Please.
Ms. Mehta, the woman in this video, Ms. Lentz, if you could get that back up on the screen, the woman in that video was Jessica Marks, correct?
Yes,
And the background is your bar?
yeah, they were seated in a kind of a corner where you're correct. There is that brick
Objection.
wall that meets the cement.
Objection, Your Honor. Best evidence. I asked that opposing counsel enter this exhibit prior to having the witness testify about contents from the screenshot of the video.
Mr. Joseph, you can't have it both ways. You can't say there's a lack of foundation and then say she hasn't laid foundation, therefore she can't ask any questions about it. The objection's overruled.
Yes, Your Honor.
And Ms. Mehta, from the vantage point that this video is taken, you can tell that Morgan Levin was the one taking the video.
Yeah, when I
Objection, Your Honor, lack of personal knowledge. This witness doesn't have any of the personal knowledge to know who took that video unless somebody told her, which would be hearsay.
Your Honor.
Sustained.
Yes, Your Honor.
Your Honor, I didn't hear that. Was that a sustained ruling or an overruled ruling?
Sustained, unless you can lay some foundation that this witness would have personal knowledge as to who took the video. The objection to that question and answer is sustained.
Yes, Your Honor.
Well, Ms. Mehta, at the beginning, my apologies, Ms. Mehta, when Jessica Marks and Morgan Levin walked to your bar, they were seated at table 4, correct?
Yes, they were.
And that night, you were the one who was up on the rooftop taking orders, weren't you?
I was. I was taking orders on the rooftop and on the floor level bar.
And this video was taken on the rooftop of Sunny's rooftop bar, wasn't it?
Yes, that's what it appears to be.
Your Honor, at this time, the plaintiff moves Exhibit 10 into evidence.
Mr. Joseph?
Your Honor, I still object as this witness still doesn't know when this video was taken and was only showed this video after the fact. She never saw this video the night it was filmed. Nobody ever showed it to her the night it was filmed. And again, I'd say that opposing counsel could have entered this video on Morgan Levin, the person that actually took this video, and can testify to its contents.
May I respond, Your Honor?
Ms. Mukavitz, can you lay foundation with this witness that this video accurately depicts the decedent at or near the time of the event?
Your Honor, Ms. Mehta, she testified that this is the woman in the video. She has testified that the background is her bar. And Your Honor, pursuant to the stipulations in today's case, this video was filmed at 11:11. At that time, Ms. Mehta was outside on the rooftop. If Ms. Marks was acting as how she was acting in the video, Ms. Mehta would have known that.
Your Honor, may I respond?
No, sir.
Yes, Your Honor.
Ms. Mukavitz has refreshed my recollection as to the stipulation as to foundation for this video, that it was taken at a particular date and time. Now that this witness has said that it accurately depicts the general location of the bar, that's enough for a prima facie showing as to admissibility as to the authenticity of the exhibit. The objection is overruled.
Yes, Your Honor.
Ms. Lentz, if you could play that video for the jury.
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. You know, I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Ms. Mehta, Ms. Marks, she's acting intoxicated in that video, correct?
I never saw her acting that way that night, but when I
Ms.
did see
Mehta?
her,
Ms. Mehta, I wasn't asking you if you saw her acting that way. In that video, she was acting intoxicated, wasn't she?
she seems to be displaying some signs of intoxication.
She's loud.
I mean, from what I could tell, it sounds like she's a little bit loud, but I wouldn't say that she's yelling.
Ms. Mehta, is that a yes?
Sure.
And she doesn't seem to make a whole lot of sense in that video, does she?
No, she doesn't.
And at one point, she's confused as to which drink is hers, isn't she?
Objection, Your Honor, lack of personal knowledge. This goes to the mind state of Jessica Marks, and she can't testify why Jessica would have reached for another drink.
Your Honor, may I
Objection.
respond?
Objections overruled. The question did not call for what was going on in the decedent's mind, but rather what appeared in the video.
Yes,
You can
Your
answer the question if you remember it, Ms. Mehta.
Ms. Mehta, at one point in the video, Ms. Marks, she appears confused as to which drink is hers, correct?
Yeah, like you said, she did seem to go grab a different drink, but then grab the White Claw instead.
And most of the things I just mentioned, those are signs of intoxication that you were taught to look for in your class of beverage responsibility, weren't you?
Yeah, I was.
But you chose to ignore the signs and you continued serving her anyways.
I thought she was buzzed, but if I had reflected on it for a little bit longer, I would have stopped serving her.
Miss Mehta, on March 24th, 2019, it was your job to stop her, wasn't it?
It was.
But you didn't?
Again, I just thought she was buzzed. And when someone is buzzed, it doesn't necessarily mean that you need to cut them off. But
Miss Mehta,
I should have cut her off.
is that a no? You didn't cut her off?
I didn't.
Thank you, Your Honor. I have no further questions.
Redirect?
Briefly, Your Honor. Ms. Mehta, I want to talk about that video they showed you on cross-examination. Were you anywhere in that video?
I wasn't.
Did anybody ever show you that video?
Not on the night, but it was only until my deposition with that attorney that he showed me the video, and I watched it right then.
While that video was being taken, did you know about it?
No, I didn't. My best guess, since I don't really know where I was when that video was taken, but I wasn't anywhere around them. I was serving other customers.
Did you ever see them take that video?
I didn't.
If you had seen that video, what would you have done?
I would have cut her off immediately. I wouldn't have let her drive off. I would have called her an Uber.
Thank you, Your Honor. Thank you, Ms. Mehta. I have no further questions.
Ms. Mukavitz, anything else for this witness?
No, Your Honor.
All right, thank you, Ms. Mehta. You can step down. Any further evidence from defense?
No, Your Honor. With that, the defense rests.
All right, why don't we take 5 before closing argument? Is 5 enough time for a break for counsel? Ms. Mukavitz?
Yes, Your Honor, it is.
Mr. Joseph?
Yes, Your Honor. That sounds great.
All right, 5 minutes starting now. All right, we have all counsel. Our 5-minute break is up. It's time for closing arguments, and we'll start with Ms. Mukavitz. And Ms. Mukavitz, you're currently muted.
Thank you, Your Honor. May I proceed?
Yes.
May it please the court. They made the choice to ignore the signs. Members of the jury, on March 24th, 2019, Sonny's Rooftop Bar ignored the signs. They allowed a 19-year-old girl to walk into their bar. And they then served her drink after drink after drink till she was stumbling and she smelled of alcohol. But Sonny's Rooftop Bar didn't cut her off. And that was their job. Members of the jury, it was their job to cut her off when she was obviously intoxicated, and they didn't do it. They ignored the signs and they simply watched as Jessica Marks walked out that door into her car. We all know what happened next. Jessica Marks, a 19-year-old girl with her whole life ahead of her, she drove off the side of the highway. And we are here today because when Jessica Marks drove off the side of the highway, she died. We are here because today my client, Ethel Marks, she has sued Sonny's Rooftop Bar for the wrongful death of her daughter. And we are here today because in the state of California, there's this thing called the Dram Shop Act. And that act states that any business, they are liable for the death or injury of anybody if it is the result of them serving an obviously intoxicated minor. And that's what happened on March 24th, 2019. You heard Miss Mehta when she told you that Jessica Marks was obviously intoxicated, when she told you that she should have cut her off. But members of the jury, she didn't. She ignored the signs and she served her anyways. Now today, we as the plaintiff had the burden of proof. We had to prove to you by a preponderance of the evidence that it was Sonny's Rooftop Bar who played the substantial role in her death, because they served Jessica Marks when she was 19 years old and a minor and clearly intoxicated. But members of the jury, you heard Miss Mehta when she admitted that Jessica Marks was a minor, when she admitted that Jessica Marks was obviously intoxicated, and when she admitted that she served her anyways. Now today, the defense has claimed that the only thing in dispute is that the result of Sonny's over-serving her when she was obviously intoxicated, that was a substantial factor in her death. But members of the jury, let's talk about the actual wording of the Dram Shop Act. The Dram Shop Act states that any business licensed to sell alcohol in the state of California, they are liable for any death or injury that results from them serving an obviously intoxicated minor. And Sonny's Rooftop Bar, they made the choice to ignore the signs and serve a minor when she was obviously intoxicated. And at the end of the night, it's true. Jessica Marks, she made the decision to get into her car. And she made the decision to pull out of that parking lot. But members of the jury, today you heard that her autopsy revealed her blood alcohol content to be 0.16 BAC. That's twice the legal limit for adults and 16 times the legal limit for minors. Someone with a BAC that high, they can't make reasonable or rational choices for themselves. It's the whole reason why the Dram Shop Act exists, to protect those who can't protect themselves. And members of the jury, on March 24th, 2019, Sonny's Rooftop Bar, they ignored the signs and they failed to protect Jessica Marks. And remember, earlier in today's trial, Morgan Levin told you that before they even got to Sonny's Rooftop Bar, Jessica and him, they were already drinking. Jessica had 1, maybe 2 glasses of wine. But you heard Morgan Levin when he told you that as the car got closer and closer to Sonny's, Jessica was already showing signs of intoxication. Her eyes were red and watery. She wasn't making a whole lot of sense. And you heard Miss Mehta when she said that Jessica Marks practically dragged Morgan Levin into that bar. But Miss Meta, she didn't do anything about that. She noticed Jessica Marks as she was walking in the door. But she ignored the signs. And she didn't do anything about it. Which is why, members of the jury, I'm asking that you find Sunny's rooftop bar liable for the death of Jessica Marks. Because they ignored the signs. And it was their choice to do so. Thank you.
Thank you, Ms. Mukavitz. And for defense, closing.
Yes, Your Honor. May it please the court. Ms. Mukavitz, members of the jury. Choices. The case you heard today was a case about choices. Now, Ms. Mukavitz just got up here and spoke with you for 7 minutes, arguing that Jessica Marks was obviously intoxicated the night of March 24th. But as the defense, we actually agree. We agree that Jessica Marks was drunk when she was served. But this case isn't about how intoxicated Jessica was that night. It's about who's responsible. Now, in my opening statement, I told you you need to answer one question. Whose choices led to this tragedy? What you heard today in court was that it was Jessica Marks's own choices. Members of the jury, I know that's a hard thing to hear. To hear that a 19-year-old girl's own choices could have led to her death. No parent should ever have to go through what the Marks family is. And while we recognize this is a difficult situation, we're here in court today to find the truth. Because we don't come to court to do what's easy, we come to court to do what's right. So let's take a look at what the plaintiff is actually claiming. The plaintiff has brought a claim of wrongful death. And when they came to court today, they came with that claim, and they also came with something else. Something called the burden of proof. They have to prove that Sunny Meta knew Jessica Marks was obviously intoxicated, that Sunny Meta still decided to serve Jessica, and that as a result of serving Jessica Marks those drinks, she passed away. They have to prove these claims by a preponderance of the evidence. Simply put, they have to prove their case more likely than not. But the plaintiff didn't meet this burden in court today because they couldn't prove one key fact. They couldn't prove that serving Jessica Marks is what caused her death. As members of the jury, instead, you saw that it was Jessica's own tragic choices. Well, let's actually go through those choices one by one. First, the choice to go to a bar underage. Today in court, you heard from Morgan Levin, who told you about her and Jessica Marks' plan to go to Sunny's. She told you that Jessica drove there herself, even though it means she'd have to drive home too. You also heard from Sunny Meta that Jessica was eager about going to the bar. She even pulled Morgan Levin inside. That was her own choice. The second of her choices, to drink alcohol. You also heard from Sunny Meta, the person that took all of Jessica Marks' orders, that she ordered for herself every time. No one ever ordered for Jessica. She made her own choice. But opposing counsel showed you a video of her drinking that alcohol. They said Sunny Meta ignored the signs. But how could Sunny Meta ignore signs that weren't even there for her in the first place? She told you that she was nowhere near when that video was taken. She had no clue that that video was getting taken. But she told you if she had known that video was taken, if somebody had showed her that video, she would have stopped her. She would have cut Jessica off and stopped her from driving. But you can't prevent a problem that you don't know about. You can't ignore signs that aren't there. Now let's talk about that third choice, the choice to drive. You heard from Morgan Levin that Jessica Marks made her own choice to drive to and from the bar. Now, Ms. Mukavitz said that when someone's under the influence, they can't always make their own choices properly. Members of the jury, I want you to realize that Jessica Marks was completely sober when she made the choice to drive to Sunny's. She made that choice even though she knew she would have to drive home. Morgan Levin even told you that she made the choice to drive to the bar knowing she'd have to drive home and offered to leave her car there overnight. She offered a spa in her Uber as well, but Jessica was determined to drive. You even heard Morgan Levin say herself that she tried so hard but couldn't convince Jessica to get into her Uber. Jessica had made her choice. Jessica was determined to drive home. Members of the jury, that could have been any bar on any night. Jessica could have made the same series of tragic choices anywhere. She could have still made the choice to go to another bar underage. She could have still made the choice to drink alcohol there. And she could have still made the choice to drive home. But we can't hold someone accountable for somebody else's choices. While those choices were tragic, we have to ask ourselves, who made those choices? Today in court, sadly, you saw that they were Jessica's choices. Now, members of the jury, you have a choice to make as well. You have a choice of who you hold responsible for this tragedy. The law says that even when that choice is difficult, you have the duty to make the right choice. And that choice is to find Sunny's bar not liable. Thank you.
Thank you, Mr. Joseph. And Ms. Mukavitz, rebuttal?
Yes, Your Honor. Members of the jury, Mr. Joseph just tried to tell you that it was Jessica Marks' own choices that caused her death. But let's remember, on March 24th, 2019, Jessica Marks was a minor. She was under the age of 21. Well, members of the jury, we all know that young people, they make mistakes and they do things that they're generally not supposed to do. But on March 24th, 2019, Sunny Mehta was the adult. Sunny's rooftop bar, they were responsible. They were responsible for their patrons. But Jessica Marks, they didn't protect Jessica Marks. They made the choice to ignore the signs. You heard Sunny Mehta when she told you that she knew Jessica Marks was obviously intoxicated, that upon reflection, she was showing the signs, but she chose to ignore them. She chose to turn her head the other way, and she served Jessica Marks drink after drink after drink until her BAC was 0.16. And members of the jury, someone with that high of a blood alcohol content, they can't make choices for themselves. The choices they made are going to be influenced by the alcohol in their system. And on that night, it was Sunny's rooftop bar that allowed that much alcohol to enter Jessica Marks' system. And Mr. Joseph, he had the audacity to blame Jessica Marks for her own death because Sunny's rooftop bar, they didn't stop her and they ignored the signs. Thank you.
Thank you. All right, and we'll give our scorers a moment to complete their ballots and submit them. And then once they are submitted, we can take some feedback. And while we're waiting, I will just congratulate everybody on making it through the third round of Gladiator. I think this competition is aptly named because it feels like you're in an arena getting beat up all day today. So congratulations to all four of our competitors for just surviving 3 rounds of pretty heavy duty mock trial today. So hats off. And then as soon as I see in the chat from our bailiff that we are submitted, we can start with some short comments.
Yeah, we have to wait for each judge to submit the ballots. Once you've submitted your ballots, if you could come on screen, that would be awesome. but I'll still need to get the approval from Tab before we get started.
All right. If we were in what used to be my courtroom, I would use this awkward moment to tell you about the great seal of the state of California that would be behind me. But I don't have it, and we're 2/3 of the way there. We got one more ballot to go. I could tell you about my fireplace, but it's relatively uninteresting. And it looks like we have all 3 scores. So once we get the go ahead from Tab,
Okay, we can go ahead.
all right. And so we'll give some brief feedback. I've been asked to remind our scorers to give 1 bit of feedback to each of the attorneys, and please limit yourselves to that. And why don't we start with Mr. O'Brien?
Well, I just want to congratulate everyone as well. And I don't really have any individual feedback. I wrote a couple of comments instead.
Ms. DeLacy?
Hi, I'm Sarah. I'll just introduce myself because I have been working with this case already. I was the second chair for competitor at Trial by Combat, the collegiate version of this competition, like 2 weeks ago. So luckily for me, I was really familiar with the ins and outs. I was the screen sharer. And it was a really fun case, but it was great to be familiar with it and see you guys handle it in different ways. I do have a lot of individual comments. I know that there are comments that can actually help you even in this tight of a turnaround. People think that there's not, but of course there is. So I won't, if anybody wants to stay on afterwards and ask me about those, I won't take up everybody else, especially the scoring judges' time. But yeah, it was awesome. Great round.
My name's Jack Lucky. I am a newly retired judge. I retired 3 days ago. I've been doing mock trial since 1985. I will say that I really enjoyed the round. I'm going to keep my comments brief. I made extensive notes in your ballot. So your ballots have paragraphs of information. I'm just going to talk about theme and theory a little bit. Ms. Mukavitz, I felt that your theme and theory didn't shine through until your closing, and then you muddled it a little bit by throwing in the choices. And I thought ignored the signs was really powerful, and I would have liked to see you develop that. In your evidence, you were bringing out things like somebody's underage that was already stipulated to you, and I felt that that pulled away from the cohesiveness of your theme and theory. And Mr. Joseph, I felt that your theme and theory was really cohesive. I got it. I think the issue for me there was, even if everything you say is true and the decedent made horrible choices, you'd still be liable, because anybody that is fighting a Dram Shop Act cause of action has somebody who made the choice to get into a car and kill themselves, right? So I think that talking more about what your client could have seen, I think the choices are important, but I think that they're secondary to look, this is why my client isn't liable. She didn't see what might have been obvious to Ms. Levin. And I think that that would have made the focus of the theme and theory a little more tailored toward the element that you said at the very beginning. Judge, we're fighting this one element. And then your theme and theory was kind of collateral to the element that you said that you were fighting at the beginning of the case. But excellent job overall. You should all be very proud of yourselves. And we'll release everybody, but I'll make the same offer as Mr. Lacey. If you want to hear me babble, I'll be happy to. Actually, no, you know what? Because I'm scoring tomorrow and I'm scoring semifinals. And just in case I see any of you again, I probably should not.
Yeah, I'm not going to be judging again. So.
Feedback. But like I said, I wrote paragraphs in your ballot, so you got plenty of information. Great job, everybody. Okay.
And my offer goes to second chairs as well, by the way, not just the competitors if you want to, because yeah, I've been there.
All right. And everybody is free to sign off. Great job, everybody. See you tomorrow.
Good
Thank you
job.
so
You did really
much.
good.
Great
Thank
round
you
up.
guys so much. I really appreciate it. I was actually wondering if I could stick around because I had a question about for tomorrow, just like a tip.
Yeah, fire away.
I was wondering, it's about playing a witness. For playing Morgan Levin, how like I want to like come across as like realistic too, as like a kid kind of, but I don't want that to be at the expense of like credibility. Is there like any tips that you have to like still come across as really credible and like professional while still like engaging and realistic?
Yeah, so what I've found is there's people who can cry and there's people who can't. There's people who can be really sad and there's people who can cry real tears. I've seen it. It's shocking. It's amazing. It's like a Broadway performance, but then it depends on who. Have you played witnesses before? Have you ever played a sad witness where you've had to do something like that?
No, Gladiator is my first time.
Yeah, so I wouldn't do it. I wouldn't try to cry for the first time at Gladiator personally. That's just my advice. You can. Some people like are nervous and it just happens and it's great. But you have to kind of stay true to who you actually are as a person if you're going to play a witness. I'm usually an attorney. I never play witnesses. I had to fill in a couple of times as defendant when someone couldn't make it to a tournament. And I just kind of found like if you just act like a real person and yourself a little bit, like you are a real person. That's what you're playing to. Scores, most of whom are seeing this like a real trial. They don't see mock trials. They don't see the theatrics in daily life, and they're not expecting that. And sometimes they prefer realistic witnesses. So I would just say kind of test it out on your own. If you can't cry, don't try to cry. Number one tip. It's just not going to work. Everyone's going to be uncomfortable. Sometimes that's hard to watch.
Yeah. Okay, thank you so much. I really appreciate it. And thank you guys again for putting aside the time to do this. And I had a really great time.
Yes, absolutely. I have one tip for the attorneys. I have a couple. I don't know if you want to hear them. They're very small and they're things that you can adjust. They'll be 5 minutes.
Yeah, I'd love to hear them.
Yeah.
Awesome. The first thing is about pretrial. It was a little bit difficult for me to watch you guys invoke Rule 603 after you were like, our party reps are in trial. Like 603 is not something you need to invoke if no one's sequestered in this trial. Is anyone not like constructively on the Zoom call or?
In Levin.
Yeah.
Okay,
Levin,
so
rep.
gotcha. Okay, so I think that because what the judges have been told in advance of training is that you're allowed to invoke 615, and you know, like I think it would be better to make it a little bit clearer because sometimes like one comes on screen, there's two party reps in this trial. It was a little bit confusing. And I, having done this case, forgot that you weren't both going to be in trial. So, and I saw like, it was just kind of a little bit funny. The next thing is about the screen sharing. So I think it's tough. I don't like having to ask every time before I screen share. Like, trust me, it's difficult. But something that we found, at least with the attorney I worked with, is that there's an element of naturalness that's missing when your second chair screen shares for you and you didn't ask. They just do it, except for in a speech. You know, like you guys wouldn't name the exhibit, you wouldn't name the thing you wanted. You just be like, could we get that up? Or sometimes not even that, it would just go up. And it's fast for judges. And it also, like in real life, if there's a record, you want it to reflect what you are showing. And instead of saying, let the record reflect, I'm showing Mr. or Mrs. So-and-so this, if you just ask your second chair, you're kind of involving them a little bit more. You're remembering that someone else is there, and you're reminding the judge that a piece of evidence is about to go on screen so that they can pay attention if they weren't. So yeah, that's something that you could deal with before tomorrow. Oh, your audio, Miss Care, is not good. I don't know what happened, but I was having a really hard time hearing you. And I didn't detract from you because of that. I understand it, but then again, there was portions of your testimony I could not hear. And that naturally is going to make it more difficult to empathize with you, like as a witness. Do you have AirPods in, or are you just using? No? Okay. I would see what you can do about that before tomorrow. Maybe there's someone who could help you out. I don't know. But that it was hard to listen to. And I don't know if the attorneys thought of this. If it isn't a quick fixable issue, I'm glad you didn't do this. But normally, like, I would say something if I was the attorney, be like, I'm having a hard time hearing you. Like, if you're having a hard time, like, your scoring judges are probably having a hard time too, you know? And then on cross, you have to get up and sometimes you can't even tell if it's yes or no, like literally because you can't hear. And you just don't want that to take away from your performance. So don't be afraid to like mention that if it happens. If there's nothing you can do, that's fine. But it was a little weird the way that everybody just kind of ignored it. And it was like, okay, there's an audio issue here, you know, like we need to address this so that you can do your best. Yes.
Hey, Chloe, I thought your audio in round 1 was good. So whatever you were doing in that round worked.
Is it better now than it was during the trial, would you say?
Yes, so much better right now.
I was using a different microphone. I have a webcam that I was basically using, and I was using that one. But in the first round, I had used my computer audio. So I wish I had known that.
I've been there.
Yeah.
Zoom mock trial. You try to get fancy with the microphones and then it all just goes down the drain. I've been there.
Yeah.
No problem. I'm glad it wasn't a round where you were an attorney. That would have been a lot more difficult. Luckily, you just had to speak for a little bit as a witness. I think that the last thing that I want to say here is that I did this year. I read scripts when I needed to read a script. It happens, especially for a competition like this, when you're a witness, when you're an attorney, you're just meeting each other. It's really hard. If you can tell someone is reading, no matter how great they are, you can just tell, and it just detracts from your performance. And I did this all year, and so I'm such a hypocrite for saying this, but there was moments where I could tell everybody in this trial was reading, and you were at your best when you were not reading. Like, seriously, especially you, Joshua, you were at your absolute best and you excelled when you were not looking at a script, when you were doing a recross, when you had to respond to an objection, when you had to make an objection. Those were the moments where I felt like you shined, and your scripts hold you guys back. And I think that it's really important to be able, no one did there was a little bit of theme flipping actually in your closing, Miss Mukavitz, sorry, I'm not sure if I'm saying that right. But I thought, like, you know, there could have been more responsiveness to each side. And it also looked like you guys were visibly thrown off when the script wasn't there. So, you know, I don't know how much memorization you can do, but you guys know what role you're playing tomorrow. So as much as you can do to prepare and just get to know the witness statement, whatever, like if you're comfortable with it, like a lot of mock trial is improvisation, and that's what makes people good at it. And I think that you guys are really at your best when you do that. So if you can find more moments to do that, and if you can just keep your eyes, it's really gonna help.
I have a question then. Was there any specific moment where it looked like I was reading? Because once Mr. Joseph, when he announced that he wasn't doing the affirmative defense, I threw everything out the window, and I everything like I just made it up as I was going.
Oh, isn't it in a pretrial order that you can't pursue an affirmative defense for this? Okay, never mind. Maybe this is different. I'm thinking about a different case.
There were 2 affirmative defenses. The second one was and he said
Yes.
he wasn't going to be using either. And so I
remember that now. Yes. Yes, honestly, it wasn't as noticeable, I think, on your part, but what I did feel is that when you got an objection or something, and it was just something that you weren't quite, like, you seemed very natural, and like when things were going as they were planned, and then when something interrupts that, it's just like there was a little bit of flustering happening there on both sides. But the eye thing, no, like I didn't notice that as much. It's more just, it can happen whether you have a script in front of you or not, to be honest. It's not entirely about reading. It's just more noticeable when it's with reading. Yeah, I have more notes, but to be honest, I feel like I'm wasting your guys' time. So yeah, this was great. Great round, you guys. You were both fantastic.